Now, will. Today's topic is will. How to basically write a will and why will should be written is basically today's topic. We receive many queries how to write a will, whether it requires registration, whether it's stamp paper, it should be written on the stamp paper. So to reply all your query, we are making this video. My name is Girish Rao. I'm advocate and solicitor, having more than 28 years of experience. And this video is brought to you by Legal Scholar Academy. Legal Scholar Academy conduct different courses on different topics of law, like Master in Drafting of Agreement, Master in Drafting of Pleading, Master in RERA, many other such topics on which Legal Scholar Academy conduct the courses. If you want to know more about it, you can connect with the number which is scrolling down here. Then, in addition to that, Legal Scholar Academy also conduct webinar on every Friday at 7:30 p.m. Those webinars are free. Those who want to attend this webinar can attend this webinar. For that purpose, you can connect with the number which is scrolling down here. So now let's begin our today's topic. But before I start today's topic, it's my request to everyone to kindly subscribe to this channel. Legal Scholar Academy regularly uploads different video on different topics of law, which will be a lot of value addition for you as per knowledge of law is concerned. So I will suggest everyone to kindly subscribe to this channel. And this is something which you should not forget to like this video, because I am sure you are going to like this video. Okay, let's now begin our today's topic, that is will, how to draft a will. Now when we talk a will, first we should understand what is will. So let's understand first what is a will. Will is nothing but basically a document written by a person, or you can also call it instrument written by a person, declaring that how his property should be distributed after his death. Section 2H of the Indian Succession Act defines what is a will. Will means legal declaration of intention of a testator with respect to his property. With respect to his property, which he desires to be carried out into effect after his death. Basically, a declaration which is given, which is documented in writing, it is called as a will. That a person who is writing a will, how his property should be distributed, that is to whom that property should be given, is what will should contain. Now then second question also comes, who can make a will? Section 59 of Indian Succession Act deals with that. Any person who is of sound mind and is major, basically a person who is capable of making a contract, can make a will. The married woman can make will of her property. A deaf, dumb, blind can make will if they know what they are doing. A insane person can do will during the time when he is of sound mind. Because a person can be insane, but at the same time, at some point of time also, he could be of sound mind. So if he is making a will when he is sound, then also he is entitled to make a will. Person cannot make a will when he is not in a state of mind to know what he is doing. For example, intoxication, illness, or any other reason. See, basically, often when the dispute arises in respect of will, these are the grounds which it is taken that he was not of a proper mental state of mind when executing the will. So often the practice is that you also attach a doctor's certificate certifying that he is having a stable mind, he is knowing what he is doing. It is practice and it is practical also to attach that kind of a certificate from a doctor. Now, what are the advantage of making will? See, when you make a will, then there will be clear intention how the property should be distributed after the death of the deceased. so that there is no dispute among the person who claims to be legal heir of that person. If will is not made, the consequences of that is that the property will have to be distributed as per the Indian Succession Act or Hindu Succession Act, whichever the act is applicable to that deceased person. Deceased person means the person who has expired. What happens in that case is that the dispute starts about distribution of the property. At times, matter goes into the court. So then once the matter goes into court, you are again stuck. So it's always better you make a will, so that will once made, on basis of will, the person who is entitled to what property can make his claim, and that only requirement could be that if it's in the Bombay or it's in the respect of Bombay or other cities, metro cities like Bombay, Madras and Calcutta, there is a mandatory that it should be probated also. Otherwise, technically, probate is not required in respect of will. Yes. And in some government agency also will insist for the will and may request also probate also. See, always better to make a will, otherwise unnecessarily the legal heir on whom you decide to give that property will get entangled in the dispute among themselves. Now, our main topic, how to make a will. When making a will, you have to remember 5 points. 5 points. First point is that appoint a person as an executor. What is executor? Executor means you are naming a person who is going to do the things as per the will. Means a person who will act as per the will. A property is supposed to be given to suppose your one son, so that whatever deed of transfer or whatever is required, he will execute. So all the things which are required to be done under the will is called as executor. So you remember what is it? Executor. So you will have to appoint some person who you can trust, who is going to distribute the property as per the will. He is the executor. Then make all detailed list of your property. Second is make detailed list of your property which you are owning, and that after that third part comes in that to whom you wish that property should be given. That is the third case. So first is who you are, what are your properties and whom you want to give those property. Then signature, you will have to sign that will, otherwise that will has got no value. So you will have to sign the will. Then third part, when so fourth part is sign the will. Fifth is that there will have to be two witnesses who have seen you signing the will, or you have to tell them, yes, this is your signature. So you will require two persons as the witnesses. If there are no two witnesses, this is not a will. Court is not going to accept it as a will. Anything, if there is no witness, your whole will fails. It is the most essential requirement for the will. Rest of the thing, appointment of executor not there, no problem. Detail of the property should be there, but it is not properly, then things can be considered, it can be interpreted in different manner. But if will is not signed and there are no two witnesses, will is of no use at all. Okay. So take care of these 5 things when you are drafting a will. There is no particular format required for the will. So once you make a will, it's not a final. Tomorrow, if you want to change your mind to who the property is given, you can make that. There is absolutely no restriction on that. Whom property is given, how it is to be. Absolutely, you can change your mind. Today you make a draft will, tomorrow you change it. No problem. You have to just say that this is my last will and testament. Earlier, I cancel my earlier will. That's all is required. Nothing more is required. So remember, you can anytime, you can change your mind. Will is not final. Next question which comes is that does will require registration or does it has to be written on the stamp paper? Even not. Registration is not compulsory, nor it is required to be written on the stamp paper. So can be it should be written rather on an ordinary paper. That's all. You can type it or you can handwrite write also. Anything you can do. And it doesn't require stamp paper. Then when registration is that whether it's required registration, no. Registration is just an optional. If you want to register, register it. Even if it's not registered, it's not going to make any difference. Or it is nor a registered will have a better value and unregistered will have less value. Nothing like that. Absolutely nothing like that. You will have to prove your will in the same fashion which you miss the person who is entitled under the will, same fashion as a unregistered will, even in case of registered will. When we are talking about registration, there are two methods how can we register. One method is the normal process, like the way we register all other document, the document becomes a public document. Anyone can take a certified copy of it. Then other method is registration by deposit of a packet containing a will. What you do is that you deposit a packet which is sealed cover with the registrar, and that document then is not a public document. When you die, the person making a will die, then application will have to be made by the legal head for opening of the will. Then there is a separate process by which will is open and a different process is followed. And for that purpose, we are making a different video explaining what is it. So this was a brief presentation on the will. If you have any query about this, do kindly drop it in a comment box. We'll certainly reply to it. And once again, thank you for going through this video and do connect with us with your query and don't forget to subscribe to this channel and to like this video also. Okay, bye bye. Take care.